SJC-13705, Commonwealth versus Mark Gravito.
Attorney Daniels.
Good morning, and may it please the court. Attorney Joshua M. Daniels for defendant appellant Mark Gravito. The basic question presented in this case is whether automatic sealing under 100C prevents defendants from getting copies of their own sealed court records. There seem to be, as far as I can understand, three competing approaches that are floating around, and I think it helps to sort of outline what they are and how they differ. I think all of them agree in principle that the defendant should have some amount of access, but I think where they differ is over how much access to allow and what the proper mechanism of that access is. The first is Justice Perino's approach below, which, as I understand it, he can't or won't fully unseal the records for Mr. Gravito or his appellate counsel, but he will let counsel come in and take notes, though not obtain photocopies or photograph them. The second is the Commonwealth's, which, unlike Justice Perino's approach, does understand the statute to provide a non-time limited opportunity to opt out of sealing by writing the commissioner of probation. But on the Commonwealth's view, if Mr. Gravito does that, then he has essentially permanently forsworn the benefits of automatic sealing and he can't get them resealed. And then the final approach is ours, which we believe is the most sensible, which is that the defendant should have full access irrespective of sealing, because 100C is best read it together with the provisions of the related Corey statute to give defendants full access to their own sealed court records. We think that approach is more faithful to the statutory purpose, and it is superior to the other approaches, because the other approaches either create immense practical problems or they force defendants to choose between the benefits of automatic sealing and their due process right to fair and equal participation in their own appeal. And we don't see anything in any source that suggests that the legislature intended to do any of that. There is no specific language in the sealing statutes, I think, that commands it. It doesn't serve the statute's recognized purpose at all. I don't think anyone has really suggested a plausible reason why the legislature might have wanted to do it. And given all that, there's no reason to think that this is what the legislature wanted, which is ultimately what statutory interpretation is all about. I'd like to get into the statute's silence or ambiguity on the specific question here.
Were you able to find any authority as to the meaning of the word seal in 1983, as opposed to subsequently with the amendment of the Uniform Rules on Impoundment?
I mean, the only other authority that comes to mind is the Commissioner of Probation versus Dorchester court case from 1978, which suggested that the meaning of seal, I can dig up the exact language, but it's something along the lines of they distinguish it from impoundment as a process for segregating court records so that they're not available for public inspection as the statute directs, something along those lines, so that they're only available to the people whom they're only available on the terms that the statute contemplates.
So in your view, is it only with the enactment of the Uniform Rules on Impoundment that that we get this distinction that the judge below relied on between impoundment and sealing?
That may be right. I think my view is sort of independent of the Uniform Rules of Impoundment, if that makes sense. I'm trying to find out what the legislature intended in the statute when it said seal. And I think the plain and ordinary meaning of seal in this context implies some restriction on access. It implies that someone is excluded, but I don't think it necessarily tells you anything about who is excluded. And for that, I'm looking, I think we have a couple of data points in terms of who isn't excluded. I think one is obviously 100D, which says criminal justice agencies are not excluded. But I don't know that anything in 100D or in the context of what the legislature was trying to do suggests that that was an exhaustive list of who is not excluded. And the other data point I think is really informative here and decisive is we have the related provisions of the Corey statute, which, as this court recognized in Pond, are supposed to pull the sealing statutes and the Corey statute are supposed to pull in the same direction, and they're supposed to accomplish a unified purpose. And so it doesn't make sense for there to be a right of public inspection for the subject of sealed Corey records, where the subject of the Corey has the right to inspect and copy those records. And yet under the sealing statute, they don't have the right to inspect and copy, especially when you consider why that public inspection right, that subject inspection right is there. It's, I think, to recognize that I think Pond actually said this at one point, which is that it's meant to allow the subject of the record to verify their accuracy, given that there are going to be entities who will have access to them and be relying on them. So you give the subject of the record the right to access them, and if they're wrong, then the subject can go about getting them corrected.
And that's expressly provided.
It's expressly provided in the Corey statute. And I think we sort of read these two statutes in pari materia in the old language of the cases. They're related statutes. They're supposed to be read in harmony with each other.
Can you tell me what happens practically if we go to your model and there's grand jury material or sensitive material and the defendant has access to it? What happens to the materials? What are the limits on the defendant's ability to put them in a brief, et cetera? I'm not... Or share them with somebody if he has free access.
Right. I mean, I don't think anyone... so I think the grand jury material is...
Did he show them to his friend?
I mean, if they're his record, I think so, in terms of the records that we're talking about, which are the records that were sealed under 100C in his case for his benefit.
So there's a McCarthy motion, right, with grand jury materials.
Yeah.
And the judge uses the grand jury materials to deny a motion to dismiss.
Right.
Your client obviously wants access to the grand jury materials to say the judge was wrong.
Right.
And they're under your model, they're not impounded, and he has full access to them for purposes of briefing, et cetera. Can he show them to his neighbor?
So I see grand jury materials or materials that are sealed under a different regime, such as like the Dwyer Protocol. I see those as different sealing regimes where who has access is controlled by different considerations. I think this case only presents the question of records that are sealed under 100C for the benefit of the defendant about whom the records are. And so I think that's all that my approach really addresses.
So it doesn't override other concerns?
I don't think so.
Other schemes?
I think those other regimes independently control access when they apply. I don't think the rule that I'm advocating for would disturb or disrupt those regimes.
Thank you.
Counsel, could I follow up on Justice Gaziano's practical considerations?
Yep.
So of the three verticals that you laid out right at the beginning, you say, number two, the Commonwealth's approach, this all or nothing approach, doesn't really work, and I don't necessarily disagree with you. But you dismiss Judge Perino's approach, and I wonder why, because with all of the other components, there's another practical component to your approach, and that is you're presuming that there's some legitimate reason why the defendant wants to. And in this case, it's because he's pursuing some kind of appellate, trying to vindicate his appellate rights. But what's to just say that somebody just says, I want to see what my sealed records are. And so now you've got the administrative practical headache of anybody under your proposal can just come in and say, I want to take a look at what my sealed records are, irrespective of whether or not they have a good reason, because your view is they're my records and I can look at it. And that's going to be administrative nightmare for folks because you've got to go through a process. But I'm going back to Judge Perino's vertical. Why isn't it enough to be able to use what was done after the remand from Justice Kafka, where Judge Perino says you can have all of the access you want to look at these records, take as many notes as you want, and be able to create whatever you need for purposes of your appeal. Why isn't that enough? Why is it that you say that, no, you've got to be able to have the records when you can have all of the substantive access that you want?
I mean, I think there are a couple of things that I see in there, Justice Georges, and if I could take them. First of all, I think in terms of the practical concern that you raise about, well, the defendant could come in and see these records anytime he wants for any reason. I'm not sure I'm not sure the legislature ever saw that as a problem. I don't think we have any evidence that they did. B, I don't think if it is a problem, I don't think Justice Perino's approach really addresses that problem either, because I don't think anyone.
But Justice Perino's answer has to do with a showing. There's a showing by somebody saying, I have a need for this. Under yours, there isn't. The only showing you need to make is that they're your records. Right. And that the sealing statute couldn't possibly anticipate protecting me from my own records.
Right, but under Justice Perino's approach, if I'm understanding him right, if the defendant already had access to the records from an independent source, or if he got them before sealing, no one has a substantive objection to him knowing the contents of the records, sure, which I think means that there's not actually any countervailing interest against him having the records. And the only question we're talking about, I think, is over whether he should have copies of them. And I think that question, the answer as a matter of due process has to be yes, because everyone else in the appellate process gets to have a copy on their desk. And I don't see how it's possibly fair or workable for the defendant to participate equally in the discussion that appellate litigation is all about. The appellate litigation is fundamentally a discussion about the case between the defendant, the prosecutor, and the court. And two of those people have free access anytime they want to look up things whenever they want. And the defendant can only get that access if he hand copies it as though it's the Middle Ages. And A, I don't see any reason why the legislature would have wanted to do that. And B, I don't think it's a fair system. It puts us at a practical disadvantage compared to the other participants of the process. It makes the quality of advocacy worse because we're not equally participating.
So is the rule you're looking for just one that applies to when the defendant or his appellate counsel is looking for the records for purposes of an appeal?
I think, as the amici point out, there are all sorts of other reasons why someone may need to get copies of their records, including, I think GBLS's amicus points this out, to make practical use of the new expungement remedy that the legislature enacted in 2018. And I think our approach is basically the defendant or his lawyer walks into the into the clerk's office. There is a process for verifying that these people are who they claim to be, that either it's the pro se defendant who he shows ID and it's verified that yes, it's the same birthday, it's the same driver's license, whatever, and the clerk gives him access of the record, or if it's counsel, it's verified that it's about the same, that like they claim to represent the same defendant, and they walk in with maybe a Corey release or maybe an affidavit signed by the defendant that's notarized. We're not saying you can't check ID, but once you've verified that the person who is seeking access to the record is the defendant or someone who represents the defendant, I don't think there's any suggestion in the legislative history or in the text that they're meant to be excluded from the universe of people who have access here.
But it's not access that you're seeking. You're seeking the right to photocopy.
Yes.
Okay. And so where is that in the legislative history or the statute or?
I think it goes back to reading the provisions of the related Corey statute, which include a right to inspect and copy your own sealed Corey records, the way the definitions are structured. And so
although the legislature saw fit to put those provisions in the Corey statute expressly, you think we should read that into 100C because the two were meant to go hand in hand?
yes, because they're meant to work
Usually
together.
when the legislature says something expressly in one statute, it doesn't in the other. We don't do that. So what's your best argument for reading in to 100C the express defendant's rights that are in Corey?
I mean, I think it is the related statutes canon, and the fact that there's no specific language in the sealing statute that forbids that result, or that suggests that the legislature didn't want that result. I think I would be on much weaker footing if the sealing statute had said something along the lines of only criminal justice agencies have access to it in express terms, not just criminal justice agencies shall have access, notwithstanding anything we might have said, but only criminal justice agencies shall have access to it, or no one shall have access except for these people. Then I think there would be a more natural inference that they were trying to be
You don't think
exclusive.
that comes from the word seal?
I think seal, again, doesn't directly speak to the issue of who is meant to be excluded.
But then the statute says who is meant to be included.
Right, but I mean, I think ultimately these readings depend on what your assumptions are about whenever you're dealing with an enumeration and you're trying to figure out whether that enumeration is exhaustive. I think it ultimately does depend on sort of the context of what the legislature is trying to do. To use a more conventional example, if I go to a restaurant and I see a sign that says no dogs allowed, or patrons must have shirt and shoes to be served, I wouldn't naturally think that it's okay to bring in my cat, or that pants are optional. I would understand, based on what the person putting up the sign is trying to do, that they did not mean that enumeration to be exhausted. And similarly, I think you have to look at what the legislature was trying to do here, which was they were trying to keep these records out of the hands of potential future employers, potential future housing providers, potential future service providers. There is not a whisper in the legislative history or in anything anyone has ever said about the statute that suggests that they were worried at all about the defendant having copies of his own sealed records from the trial that he just sat through. I see that my time is up. If there are no other questions, we would ask that you reverse Justice Perino's order and guarantee criminal defendants free access to their sealed records under 100C.
Okay.
Thank you.
Thank you. Okay, Attorney Eisenhower.
May it please the court, Rachel Eisenhower for the Commonwealth. To some degree, the district attorney's office actually shares interest with the defendant. We do want appeals to run smoothly. It's a lot easier for us practically if both sides do have the same materials. And we want litigants in other proceedings to be able to access evidence from an acquittal if it's necessary for that proceeding. For instance, we have victims who go on to bring civil actions against defendants. And that's been happening by court order. If they move for a subpoena, we move for a motion to get an order, and that's how that's been going on. But at the same time, there are two things in tension. One is the separation of powers problem, that the legislature has set up a system, and I'm very reluctant to get in there and make it better. And the second thing is the court has inherent authority.
I think the legislature meant to include.
Absolutely not. I don't think they intended this result. Maybe I'll let you finish your question, because I think
Do you know what it was?
Yeah, I was guessing. So why don't you finish, and then
I was going to ask whether you think the legislature meant to keep those sealed records from the actual defendant, the records to whom they refer?
So I don't think they intended a person to have to pursue a direct appeal without being able to look at the records. But I do think they probably thought that once they were sealed, and then even if you came in and showed your ID, you weren't going to be able to go look in the book.
Why do you say that?
Just because of the meaning of the word sealing. Now,
What is, yeah, so
and
what
that's
is,
the
what is
problem.
what is your best definition of the word sealing?
So I'm going on the modern definition, and from the post-Pixley definition of sealing being separate from impoundment, meaning that the parties don't get to look. But I recognize the problem with that. I don't think there's any evidence that it meant that to the legislature in 1973 or 83 or 84. Now, it would have meant that to the 2018 quarry reform legislature, but they wouldn't have addressed this because this section wasn't active because it predated JF. So to attribute.
To answer my question, what is your proposed definition of the word seal?
I think we could treat it as ambiguous here. We could treat it as ambiguous. I have been using the definition of the word seal to mean that the court puts it in a box and nobody gets to look at it. Nobody, not even the parties. That's how, except in 100D law enforcement, another court could ask for it.
But why would it make any sense to your opposing counsel's argument to read sealing that way in 100C when the whole point of the statute was to protect the interests of the defendant?
So candidly, it does not.
It doesn't.
And
So
the
usually
reason-
we don't construe statutes absurdly.
So part of the reason I have defaulted back to the statute is because in the other direction, I have, it's not really a floodgates concern, but a question about whether this is really about just the defendant, because it's easy to say these are his records, he needs them on appeal. But the next question is, what if they were co-defendants and the co-defendant was the acquitted party and it was the other co-defendant who was pursuing the appeal? Then it would no longer be his record, except insofar it was a joint trial. And the next step is people like my victims who need to bring civil actions against the defendant. It's very much not their record. It's the court's record, but the defendant's record. So there are more problems than just the defendant's own records. And that's one of the reasons where even if it moves from sealing to impoundment, I don't see it as
There's
a fix.
nothing, as far as I could tell, about in 100C that deals with the concerns that you're now raising.
No.
So to your Article 30 point, is it really our job to fix it for victims or anybody else who might want to restrict access to things that they publicly disclosed previously?
So I feel like I have the two warring wolves inside of me. And one of them is the Article 30 wolf that very much says, no, it is not this court's job. And the other is the court's inherent authority. The court is the one running these other proceedings, these other actions. And so to some extent, should there be inherent authority to make sure that those run smoothly and that people get what they need if the legislature has created an exit to nowhere by accident? So it is intention. It is intention. And that is why
Is it intention, though? Because I don't see anywhere in 100C that says the defendant shall not have access to his own documents.
It's true. It does not. And there is that other statute over in the, is it 167.6? I may be saying that wrong. But that says that in the Corey contracts, he's allowed to examine his own. So there it is. There it is. But one of the reasons I was very interested in the 1980s practice is that it seemed like at the time you could go to the Superior Court and have some sort of balancing test about your need to access a sealed record, which is very interesting and different because I don't think, I would say to my brother's pillars, I think that's the fourth pillar he didn't mention, is this evidence we have from the 1980s that people actually did that and had a Superior Court practice where you would go in and you would be able to say to a judge and state your particularized need and have that addressed. So that is a fourth vertical option.
If we were to accept your definition of sealing as being a black box, and the only people who can get in are the people who are enumerated in other parts of the statute, law enforcement, and we apply that rule to the circumstance here where the defendant is seeking the documents in order to pursue an appeal, investigate the grounds for an appeal. Doesn't your definition create constitutional problems?
So I think that with Judge Perino allowing him access but not copying, it does squeak over the constitutional bar, however inelegantly.
How? So that's a new test, I think. But assume it were something like a photograph or a recording or some piece of tangible evidence. How does the attorney's ability to make notes?
And that's one of the questions I had about what was going to really happen at this event. Because if you, in an ideal circumstance where you had counsel's trial file and this access was just to compare them and make sure there were no differences, access would be sufficient. If you realize something's missing, maybe that's the point where you go to the judge and say, I'm missing a document, and maybe you get a second order.
But here he's missing all of them.
But here, well, I don't. He didn't actually technically say that, but I'll
Right, at least 10. At least 10.
I'll assume he's missing those 10.
Yeah. So that's the comparison. Here's what I don't have. Why isn't that?
Oftentimes, that's the original trial exhibits. You know,
Yeah, and that would be a problem because often original trial exhibits may be something that can't even be copied. It might have to be photographed, or it is a problem. It is a problem.
If the you were discussing the court's inherent authority and practices that predated the current incarnation of the statute as a whole, but post-dated these provisions, which then were dormant for a period of time after the First Circuit's ruling. We usually presume that the legislature does not abrogate common law and would not be abrogating the inherent authority of the court to deal with sealed matters in the manner that it has done so, unless it says so expressly. So I assume you agree that courts still have some inherent authority with respect to sealed documents. Do you agree with that?
I do.
Is that what you were relying on when you go to court to try and get these documents for a victim to bring a civil action?
Yes, that is. I am
So, sorry, can I ask you a question
sure,
about it?
go ahead, I'm
So if the court, in a situation where you're dealing with a non-defendant without these sharp constitutional concerns, and you're dealing with a victim, say, what do you think is the standard for the court's exercise of its inherent authority to grant access to someone to documents?
I think it would have to be a balancing test, much like the ones in the other sections of 100A, 100B, and 100C, where there's discretionary sealing and it's more of an interest balancing test. So I would import that kind of a consideration into that.
But are you aware in the case law of any development of such a standard?
No, I just pulled that out of those because it made sort of sense when you're dealing with sealing, that it's somehow going to be analogous to this mandatory sealing is going to have some sort of analogous status to discretionary sealing, and therefore should have a similar standard. That was the logic.
Is the Commonwealth still pressing the argument that if the defendant is permitted access to the sealed documents, it's like a poison pill, they automatically become unsealed for everyone?
So I really don't love that solution, but it seems to be an obvious solution that the legislature's included in the statute, that, you know, if that the sealing is in his control. He said it's automatically going to be sealed unless he wants to opt out, and then it isn't sealed. So usually when you talk about constitutionality, you're talking about a situation that's forced, not something that he can get out of by saying, okay, I don't want to do that. Now that's an uncomfortable analysis here.
I read that opt-out as being if he opted out for purposes of other people seeing it.
That is,
you see, otherwise it's very hard to understand.
Yes.
So if it is in the defendant's entire control, then why can't his opt-out be limited and say, I'm opting out for my purpose, but not for purposes of other people's access.
So I would come back to Justice George's mentioned administrative problems. That would be my concern. The legislature has set up a binary system where they're sealed or not sealed. And to say, well, it's really just about him and how much he wants to show people, you could have a number of different tailorings between full closure and full openness that would be a very big administrative hassle for the various agencies that deal with these records.
Why couldn't it be that the term sealing means other than the defendant, the rest of the world doesn't get it?
It could mean that.
And then the binary choice that the defendant has is he's always going to have it, access. But the binary is either the rest of the world gets it or they don't.
That would make more sense with the legislative history. I believe there's one of the amici mentioned a letter to Dukakis, I think it was, about that some people might prefer the public not guilty to be visible on their record.
So if you adopt Justice Wendland's formulation, does the Commonwealth have any concern about that? What's the downside to the Commonwealth if
Yes.
we adopt that approach?
So it doesn't solve the co-defendant appeal situation if there were two defendants and one's appealing and the other was acquitted, because there would still be the problem that there's not the acquitted defendant's privacy interest would then be up against the convicted defendant's appellate interest. Now, there may be some way to work that. I'm not sure.
I'm confused though. If the defendant is opening it up, why is that a problem for that helps the co-defendant? I'm confused by why the Commonwealth finds that a problem. Because the defendant himself or herself is deciding to open these records up. They're making that choice. It's not like someone else is making that choice.
I'm sorry. I think I was answering a different question than you were asking. I was saying what remains unresolved if we adopt Justice Wendland's formulation.
My question is, if we adopt Justice Wendland's formulation of this, what's the downside to the Commonwealth? Shouldn't you be happy with that?
Oh, there is no downside to the Commonwealth. The downside to the Commonwealth is only that it solves Gravito's case and things in Gravito's posture and possibly the one raised by the amicuses.
That's all we have to, that's all we have
Okay.
for.
It would leave open the problem of
Where one co-defendant wants to seal the documents and the other defendant wants them open to
yes.
the rest of the world. Why could that not be solved by a system of redactions? I mean, it's almost like this problem, right? Isn't this the case where the defendant was convicted of some, but not all?
Yes.
So why isn't it?
So yeah, in my two defendant hypothetical, it's very much like this, except that the person who needs to appeal is not the same holder of the privacy interest. So that's why you wouldn't be able to collapse it. Maybe it's not a problem.
It would have to be a co-defendant who has just some convictions and some acquittals, correct? Because if he had all acquittals, he's not appealing.
Well, no. If the acquitted defendant, even if it's a fully acquitted defendant, he could flummox the convicted defendant. That's my concern.
I don't see that really. Isn't the convicted defendant, his records would not be sealed?
I'm assuming a joint trial.
Right. The convicted defendant's records from that joint trial would not be sealed. And they would be the same records.
Okay.
Now there might be some tension between one co-defendant has records vis-a-vis him that are sealed and the other one has no sealed records, but.
My concern was that brought us back to what my colleague described as trying to review the whole haystack for a needle and not being able to look at part of the haystack. So that was my concern. But again, it's not really the Commonwealth's problem. It's just a future complication potentially.
Okay.